Hello, my name is Mikkel Snyder. I'm a board member of Slice, and I am the current counselor. I don't know, something about Comics U. Steens isn't here right now, so I'm running the show, mostly to introduce Corge. But thank you for coming out to the penultimate Comics U with the VLAA. We're going to be talking about comics contracts tonight. If you are still looking for punch card opportunities, we have one more extra credit at the end of this week, Saturday Sip and Scribe at the High-Low. We will have a hole punch there, and that will still get you your certificate. But otherwise, thank you for coming out. If you haven't already, we have quizzes that you can take for Betty's Bucks, redeemable the one day that they are available here. But otherwise, you know the drill right now. Most of you have been here before. So this is Gold from the VLLA. I'll let him introduce himself and what he's talking about tonight. And this is the mic, so that way the people watching from home can hear everyone in this room. So if you speak, just raise your hand. I'll come hand you a little friend here. So, cool. I'll be in the back. Take it away.
Oh, excuse me. Thank you. All right. Well, it's good to know there's one more talk being given, so at least we won't go out on a low note, right? My name is Corge. I'm an attorney here in St. Louis. I've been practicing for 25, 26 years now. My practice is a pretty general practice, but I do have a lot of artists that I do work with. So I do deal with these topics a lot. I'm also a volunteer for the VLAA, which we're gonna jump ahead and be a little out of line here, but okay. So the VLAA is a co-sponsor, and they wanted me to make a few comments about that before we started. Unfortunately, the individual was unable to be here due to a sickness in their family. So you're going to have to deal with me. I do not run the VLAA, and I am not a board member of any kind. I'm just a lowly volunteer. So whatever I say, take with a grain of salt. But the VLAA is important, I think, that you all know about, because it stands for Volunteer Lawyers and Accountants for the Arts. And it is a resource that all of you, the assumption being that all of you are artists, writers, creative types, they provide both legal and accounting help for those in need in the arts. They have educational programming workshops. They have volunteers like me who will both come out and speak. But they also have a program where you can be hooked up with an attorney or an accountant for specific individual issues that you have or that you are facing. You can go to their website and you can fill out an application to do that. Let's see here. Now, they didn't trust me, so they gave me specific language to tell you all. But essentially, the VLAA, it's a very broad definition of art. If you're on the fence or unsure, look them up, give them a phone call. The people that work there are very, very nice. They service the greater St. Louis area, obviously. So even if you're not from St. Louis County, St. Louis City, still reach out to them. They offer services. It is an organization I've been involved with now for, I don't know, probably 15 years. So it's definitely an excellent organization. It's something to keep in mind as a resource for yourselves. So now let's jump back here for a minute and look at of course, there has to be some boring legalese. Obviously, this talk, I'm a lawyer. We're talking about legal issues. This talk is not legal advice, and it's not going to create an attorney-client relationship with you or anyone at home watching on the internet. Of course, every contract, every situation is different, as I'm sure you're aware. And really, any creator, anytime you're dealing with a contract or a legal issue, you should really consult your own lawyer before signing or proceeding moving forward. What I do and what my other lawyers do is we are always very fact specific. So it's very important that your very specific situation is addressed. There's very little blanket solutions for everything. So that's so we'll start with that, and then I would have added this to my talks. And this didn't have to be a thing 5 years ago, but obviously AI has become prevalent in our society. AI is a great resource for you all, and I'm talking about the legal side. I don't even want to touch on AI and the artistic side. But it's a great resource for learning terms, for issue spotting, for putting contracts, putting things through, preparing questions, asking it questions, what you need to know. But I'm also going to tell you that I see this all the time now. It is no substitute for good legal advice. More and more, as you would expect, people are trying to do a do-it-yourself search situation, which I encourage, and everybody should be empowered to do that, and everybody needs the resources to do it. However, always look at anything AI pops out for legal solutions with a jaundiced eye. It doesn't usually understand exactly what jurisdiction we're talking about, much less even United States law versus whether this is appropriate for your situation. So highly leverage AI for any kind of legal issues you're looking at, but always remember that it is most likely wrong in the big picture. So I'm, in fact, this week I've been fighting someone who is representing themselves using AI, and it is not going well for them. So I just add that now. So now we can move forward here past this, and oh, that's right, they added this too. Oh, certainly. So if anybody wants to use their phone to get the link and the resources for VLAA, please take a moment. I'll sit on this for a second so you can take that picture and you can have that. Again, this is an organization that's worth looking into. All right, we've got a couple of pictures here still. Excellent. All right, and then at the end, I can navigate back to this slide for you all when we're done so you can have time after we're done here talking. Okay, so, pardon me. This talk is, I'm going to say, not a well-structured talk in the sense that when you're talking about a contract for a creative, especially for a comic book, they can range anywhere from a page to 50 pages and more. There are so many little aspects of it that if I were to take you through a full contract, first of all, everyone would leave in about 10 minutes. And second of all, it would be your eyes would roll in the back of your head. We're not here for law school. So what I've done instead is structured this in a way so that we hit topics. And as we hit the topics, it's just discrete getting you to know the situation. We're not going to get into the heavy law. I'm not going to get into case law. What we're going to do is hopefully introduce you to concepts that you need to be aware of. So when you are looking at your contracts, when you are dealing with situations where you do need to involve yourself with contracts, you say, okay, I'm familiar with what this is. Now I know how to look a little bit further. But with that said, I'm happy to talk about anything you all want to talk about. And I find that when we have these conversations, these talks, it is better if it is a conversation. I'm happy. I can stand up here and talk at you all night long. But if you have any questions, anything that comes up, anything you think of, interrupt me, raise your hand. We will pivot to that because I want this to be tailored to you. I want to be a resource for you. And if you get ahead of yourself, or get ahead of my talk, and there's something later, we'll address it right away, and it'll be fine. So please, if any of you have any questions from what I say, if any of you have any questions about things that you faced or thought about, just feel free to interrupt and let's talk. I prefer that. You guys would probably prefer that. But since I don't see any hands, we're just going to move ahead here and we'll just sort of start to go through these concepts. And like I said, this is not structured in a way that you would structure a contract as you read from page 1, 2, 3, 4. We're going to kind of jump around a little bit. So keep that in mind as we do this. So number one, of course, the first question to ask is why do we need these contracts? What's important to have? Why do you all need contracts for what you do? And essentially, the number one issue is a determination of who controls the work. The work meaning your artistic product. I know you've got artists, we've got writers, we've got combinations here in the room, and as you create something, the contract is really going to determine who controls the work. It is not just about who's getting paid. And what that essentially means, though, is you're going to be dealing with copyright transfers, licenses, which we're going to talk about, work for hire agreements, which is very important, which determines who owns the work from the minute that you create it. Collaboration agreements. Comics are somewhat of a unique medium where there's a lot of times multiple artists, multiple creatives involved. Obviously, you have writers, you've got illustrators, you have letterists, all these types of different specialties. And if you get together, you want to know who owns what and who gets to control things. You then have media right agreements, which of course is probably the ultimate goal of everybody, right? Who turn into Marvel and you suddenly go from a couple of comic book characters to to billions of dollars. But the media rights agreements, merchandising agreements, same thing. And then, of course, finally, I've got at the end compensation structures. You still do want to get paid. Now, I understand this. I represent a lot of artists, and I think the number one complaint I hear from artists is they'll come to me and they say, you know, I'm creating this work. I don't want to have to negotiate with someone at this point. It's uncomfortable. It's confrontational. I don't want someone to walk away and tell me no. And a lot of my clients shy away from this. The reality is, though, that if you just simply do handshakes and you get yourself in a situation where everybody says, well, trust me, we'll get to this, or we'll figure that out down the road. That's always a move for big problems in the end. And in a way, I would say this is not an advertisement for attorneys, but this is what we're good at too, is, I'm a hired gun, call me. I'll be the one who talks to another person, that we don't get offended when we talk about these things. Negotiating these things up front is definitely the way to go, because if you stick with an oral agreement, you don't even really know exactly what was promised, because you probably didn't talk about everything that needed to be talked about, number one. Number two, everybody's memory changes. I don't even remember what I had for breakfast yesterday, so I'm certainly not going to remember a contract or an agreement I got into 6 months ago, 2 years ago. You want to talk about whether the grant of the rights you're given is exclusive or non-exclusive. Did you talk about film rights? If you're just sitting around, if you meet a friend at a convention and you do a quick 10-minute comic, you put something together, you have this great idea and this great work that you produce, you're probably not going to have a discussion about film rights at this point. You're not going to talk about character designs. You're not going to, now the flat fee or advance, that's more talking about publishers. And then who owns what? These things are issues that if you have just an oral agreement, they're probably not addressed, and you're rife for going to have to fight about this down the road. Now, the written contract, of course, fixes all of this, and this is why I would encourage you always to engage with a written contract, because it'll define who owns what. It'll define the rights that are being licensed or assigned. It'll define when payment is made. We're going to get into some of these issues a lot deeper too. Credit is another big issue, especially when you're going to give your work to a publisher to publish. You want to make sure that you're getting the proper credit, whether that's a standalone item that's being published, whether that's something that's a part of an anthology. How will you be referenced, and what are their requirements for that? Again, with anthologies or publishers, who approves changes? You get into an agreement with a publisher who's going to publish and distribute a work of yours that you've created. Who controls the cover? Who controls the font on the cover? These types of things. These are important issues as well. What happens if deadlines are missed? This is another issue that's always important to put in there, especially if you're doing work for hire or work for someone else, or if there's some situation where you do have to approve changes. What are the deadlines to do that, and what happens if someone doesn't meet those? And then finally, at the end, of course, what rights come back to you as the creator? Because if you have a publisher who is going to publish your work or distribute your work, you obviously have to give them some rights to your work. At some point, you will hopefully get those rights back. When and what does that look like? These are all things that you want to make sure that you're addressing in your contracts. And again, I know I'm just sort of putting a lot out there. We're going to go into these things individually as we go down the road. If there's anything that you guys want to talk about before we get there, like I said, please interrupt me. This is, I think, something, and this is probably the most important slide here for you all, because you're not lawyers. Well, I assume you're not lawyers. You're going to be looking at contracts. You're going to be thinking about contracts. These are the 4 questions that you want to keep in your mind as you're looking through the contract to decide, what does this give you? What rights do you get? How does this agreement control the relationship between either yourself and a co-creator, yourself and a publisher, yourself and a media individual? So essentially, it needs to define who owns the work. Who owns the work currently, who owns the work during the period of time of the contract. And again, this gets back to what we just talked about, who gets rights back and when. What rights are being granted is another subset of who owns the work. And essentially, as we're going to talk about, copyright is a multifaceted item that can be subdivided into into tiny slivers. So what rights are being granted? You can give a publisher the exclusive right to publish your work for 5 years, or you could give someone the right to publish in the United States for 1 year, a certain portion of the work. It all depends. And that is, of course, also very important, especially if you start to begin to create comics and works of art that become larger and larger, or multi-volumes, multifaceted. If you create a comic book where you have a shared world with all of your characters, and that starts to become larger and larger. I know that, if you talk about, again, and I'm using this because they're easy examples, but you take Marvel, for example, there's 5,000 characters there, right? So exactly what rights are being granted. And a real world example, of course, is, as you all know, for a very long time, Fox got to produce everything that had to do with Spider-Man, even though Marvel still owned it, and Sony got to do everything with a different type of character. So you can divide all of this up, and that's going to be another important question to answer when you're looking at these contracts. Now, important to everybody, how does a creator get paid, and how do you verify payment? This is going to get into essentially audits for publishers, things of that nature. As they sell your work, how do you make sure that you're getting compensated properly for what you have agreed to? And then, of course, at the very end, and this is very important, is what happens if either the relationship ends with the individual you're contracting with, or what happens if the work becomes valuable. Again, I know that you all are producing artwork that is personal and important and meaningful, but let's be honest, we live in a capitalist society, and you never know. Your artwork might become very valuable. And if it does, that's nothing to be obviously shied away from or ashamed of. It needs to be, you protect yourself when you can before it becomes very valuable. So, comics are obviously a very unique art form. I don't need to tell any of you that, but when you apply copyright to this, it is a lot more complex a lot of times than, let's say, just and I don't mean just a book, someone who just writes a biography. Well, that's going to be your written word, maybe some pictures, that's about it. Photographs. A comic, though, you might have pitch materials, you'll have scripts, finished artwork, layouts, character design, cover art, dialogue, story bibles, finished sequential pages, a finished completed work. So this is what makes some of the issues with contracts and comics a little more complex than your average artwork, because it is made up of so many different aspects, and because, as we just talked about, copyright can be subdivided down into multiple slices. So each of these things can be grouped as an entire whole, or these things can be separated out. And as you can imagine, when you're working with both co-creators as well as publishers, these things can become very, very valuable to different parties who are involved in your contracts. Now, we're going to go into here a little bit. I said that we're just going to do kind of a grab bag of things to try and educate you and get you familiar with terms and concepts that are important. I'm not here to teach you how to draft a contract for a comic book, but we're going to first, I think, need to go a little boring, but we have to just talk about some definitions, because we're talking about copyright, and copyright is a function of statute, and anything that's a function of statute, it is completely controlled by the language that's in that statute. And so these definitions are going to be important as you go through, and you're going to start running into these as you deal with contracts and various agreements that you have to put together with other parties. So we're going to talk about when the copyright exists, who can own it, rights that are granted. We're going to talk about co-ownership and collaboration, future adaptations, derivative works, things of this nature. So let's start with fixed or fixation. And I don't know if you've heard of this, but I think this is a very, very important concept, and this is probably one of the bedrock fundamental concepts, is that in order to obtain copyright protection in anything you do, the work has to be fixed in a tangible medium. So essentially, a work is fixed when its embodiment is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. That is essentially a fancy way of saying that it is a physical item. So your ideas, no matter how great they are, no matter how fleshed out they are not copyrightable. You can tell your ideas to someone else, and you have no legal protectable interest if you're just simply talking about them without additional protection. The copyright attaches as soon as you have your fixed medium. So when you have an idea, but if you reduce it to scripts, pages, layouts, art, things of that nature, now as soon as that is created, copyright attaches to it under U.S. law. However, if you are just thinking about it, or you're talking to someone else about it, and it is not a fixed expression of your idea, that will not get that protection. And we will talk a little bit about what to do to protect ideas and things before they are in a fixed medium. You can protect those through contract, but it's not going to be protected through copyright. So those are also two separate concepts that apply to your work. Now, so again, I've got a couple of slides in here to sort of belabor the point because I think it's so important, is that an idea is not enough for copyright protection. You need a written script, a drawn character design, completed page, a story bible, a specific dialogue, or a specific visual sequence, things of that nature. Those will be protected, but just having the idea is not. Now, as an aside, and I briefly touched on this, when under the copyright scheme in this country, as soon as it is reduced to a fixed medium, meaning you've drawn your drawing, you've written your script, you automatically immediately get copyright protection. You don't have to do anything further. It doesn't require registration. It doesn't require that you submit anything to the government. I know for a long time there used to be the idea that, oh, I need to put it in an envelope and mail it to myself. These are not concepts that are important under the law. You automatically get that protection. Now, you do have the opportunity to register officially with the United States Patent and Trademark Office the copyright of anything you produce. And you do this by filling out an application, and you have to send a copy, and there's a procedure you do that I'm not going to go into. If you do that, that will also give you the copyright, obviously, but it gives you what I would sort of call an enhanced copyright. So your copyright if you don't register it, you get your copyright, and that means that is yours and yours alone to do as you wish, and others can't take it. If you register it, however, you get additional benefits that if someone reproduces your work and they are not supposed to, you now have the opportunity to sue them for statutory damages, which means not real damages. It's just a number that the government says you can go after. And you also can recover your attorney's fees if you have to sue. So those are the benefits to registering. The reality is most people do not register their copyrights, however. And if you don't register and you do have to, well, if you don't register and you end up suing because someone infringed upon your work, then you will not be able to get those statutory penalties. You will not be able to get your attorney's fees, but you will still be able to proceed. Now, I'm being a little imprecise with my language here, and I know we're being out on the internet, so I'll probably get a lot of angry comments. If you are going to sue for infringing work, you do have to register it beforehand. What I'm talking about is registering it before the infringement takes place. So that's the nuance that's there. And I'm hopefully not trying to get bogged down too much into unnecessary details. So, everyone good with those concepts? Perfect. Joint work. Now, again, this is a unique thing. Obviously, lots of people write books together. Lots of people do artwork together. But really, comics, I think, is sort of comics and music. Those are the two major areas of art that joint works are very common in. So a joint work, of course, is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or independent parts of a unitary whole. And comics, of course, as we just talked about, are often collaborative. Now, something that is important to know is under the law, joint work, contribution does not automatically equal co-ownership. So there is an inquiry into intent, and there is an inquiry into the amount that you have contributed. So again, a contract now, well, let me pause here for a minute. Take a breath. I mean, a contract, you have your statutory scheme that sets out joint work, whether you have to look into the intent, these sorts of things. However, you can always contract around the statute. So if you get together and let's say that under the law you might not have co-ownership with a joint contributor, you can subvert the law and say, no, I want us to each own half of it or be equal owners. So we're going to have a written contract that will define that. So again, a written contract can help you set the relationship between your co-creators. Now, the thing is that if you are determined to have co-ownership under the law as opposed to through a contract, what rights does that give you? If you are both determined to be joint, if it's determined to be a joint work, all authors have an equal 100% ownership of that work. They have the right to unilaterally do whatever they want with that work, meaning they can go out and have it published. They can alter it. They can have derivative works. Everyone gets 100% right, and no one can stop the other one from doing that if you don't have a defined contract that specifies otherwise. The obligation that a co-author has in a joint work is that if they do go out and they say, I want this published in this magazine, they then owe their co-authors an equal portion of the proceeds from that. So they will owe a fiduciary or a monetary accounting duty, but they do not owe any duty for deciding how to handle or what to do with the work. So as an example, if you have a joint work that you co-create with a co-author and you create this comic, your co-author could go out and sell that to be published in, for example, a magazine that you don't approve of or you don't like. You can't stop that. They have to give you 50% of the money they made off of it, but you can't stop them from doing that, and vice versa. So if you just have your oral agreement or you just rely on the common law, you might lose a lot of rights as to what you can decide is done with your work. A contract, however, a written contract, you can define explicitly, and we'll delve into this a little deeper, exactly who can do what, whether both people have to agree, all three people. Obviously, it doesn't necessarily have to just be two people, what is being done. So your contract can essentially define your collaboration a lot more clearly than the default rules would. All right. Now, derivative work. This is another big one that you always hear about when discussions about contract. So a derivative work is essentially, it's a work based upon one or more pre-existing works, which would include, it's a very large group that can include translation, a dramatization, a fictionalization, motion picture, or basically anything that is recast, transformed, or adapted from the work. I know that, for example, Betty and Veronica, the older comics have obviously had life as transformed versions in modern times. Those would be derivative works. Basically anything that springs from the work that you did. I guess Wicked from Wizard of Oz, that's another example of a derivative work. Now, again, the nature of comics being a serialized form of storytelling that is very often multiple issues and an ongoing story, by its very nature, worlds are built, various characters are created, and you are going to have a situation where it's just very natural that derivative works come from your comic book creations. And the contract, of course, is very important that you look in your contracts and you keep an eye out for derivative work, for the term derivative work and how that's defined and what rights you are given or what rights others are given for that derivative work. Because you want to make sure you hold on to all of the rights that you rightfully should have. How long am I supposed to speak for tonight?
We have the space until 8:30. So.
Very good. Okay, I'm already behind. So, okay. Now we talked a little bit about copyright ownership, and hopefully I'm not glossing over concepts too much. So please, again, feel free to stop me. But copyright ownership, we said you get your copyright the minute that you've fixed your work into a physical or tangible medium. This is a right you suddenly have and now you own. So because you own it, you can also transfer it. So a transfer of a copyright ownership can include multiple things. It can include an assignment, and this is just some legalese here, but a mortgage, exclusive license, or other conveyance of copyright or exclusive rights but not a non-exclusive license. And I want to talk about that a little bit because, and I wanted to put that language up there, not to show you that I own a dictionary, but that you're going to probably see a lot of those words in contracts that you're dealing with if you're dealing with publishers or other groups of that nature. So the important part here is over on the right side, and it's these three clauses, phrases: assignment, exclusive license, and non-exclusive license. Those are essentially the three different categories that you can have in a copyright that you can use to transfer to others. So an assignment. If you assign a copyright, essentially that means you are giving the copyright away. You're giving everything away. So if I have, if you have a copyright interest and you assign it to someone, you have now essentially given that to someone else, and it is theirs to do whatever they want to do, and it's theirs. And they can now go sell it, or they can do whatever they want with it. An exclusive license, on the other hand, a license is you're giving them the right to use your copyright. You still own the copyright, but you're giving them the right to use the copyright. So you're licensing it to them, and the exclusive, of course, meaning that you are giving them the exclusive right. So you could say to the publisher, you exclusively can publish this book, this comic for 5 years. And that means now you still own the copyright, but you cannot sell that copyright to anyone else for that period of 5 years. They're the only ones that can use it for those 5 years, but it's still you still own it. Now, the non-exclusive license would be, I can give it to you to publish for 5 years, but it's non-exclusive, so I can also have another publisher publish it. And so non-exclusive license, for example, would very often be some anthologies. They might say, well, we don't need an exclusive license, but we want to at least be able to publish it for X number of years in our anthology. And therefore, again, whenever you see license, you still own the copyright, but you might be restricting yourself as to what you can do with that during a certain period of time. And these three terms, assignment, exclusive license, non-exclusive license, are important because I think as a non-lawyer, sometimes you look at these words and you're not sure exactly what they're conveying, and it's important to make sure that you don't you think maybe you're giving permission when you say assignment, when you're really giving away the whole store instead of just letting people use it. So you want to pay attention to those terms. If you see them in contracts, they're red flags that you want to make sure you're aware of. Now, work made for hire. So I don't know how many people are maybe in this situation, but like we talked about the copyright, I'm going to keep going back to this. You put the work down into a tangible form. It now has a copyright protection. Someone owns that copyright. Someone or something owns that copyright. Something could be a company. Now, if you are working for yourself, or not necessarily working for yourself, but you're at home, you're creating, that obviously is yours. You're doing it at your direction, under your own guise. That becomes your copyright. There's a concept, though, which is a work made for hire, and that comes in two different forms, where you will create the work, but you will not own the copyright, or do not own the copyright. One of those being, the common one is an employee. So a Disney animator is told, okay, I need a picture of Mickey Mouse. Well, the Disney animator goes to work, he gets paid to do that. That Disney animator does not own that picture of Mickey Mouse at the end of the day, even though it was reduced down to tangible form. And that is because he was an employee of a company and creating this work at the direction of the company. So if you are an employee and you're being directed and told and you're paid to do that work, the company is who owns that copyright. Now, you don't have to be an employee, however, to lose your rights as a work for hire, because you can also contract with an independent contractor to have a work for hire. And this is going to be defined in the contract. And again, work for hire. This is a phrase that you need to pay close attention to if you have any contracts with anybody and you're creating anything for someone else. Because if I enter into a contract with you as a work for hire and you say, sure, and you don't understand what that means, after you've produced your work, That's now mine. I own it. You own nothing. The only thing that you get is the money that I was going to pay you based upon the terms of the contract. So you can either be an employee, which is obviously the common example that's easy to understand, or you can be an independent contractor, but if the contract says work for hire, you might not be keeping that contract. So, and this isn't even an issue of, oh, I've transferred the copyright. This is an issue of you never owned the copyright in the first place. So, the copyright bundle of rights. Again, we're touching on all of these different concepts and we're doing it multiple times, but copyright gives you a whole bundle of rights with what you create. So you get the right to reproduce your work. You get the right to prepare derivative works. We talked about derivative works. You get the distribution rights, publicity platform, essentially the ability to publish them on the internet or in advertisements, things of that nature. Publicly display. You have the right, if you own the copyright, you have the right to, you could put up a display here at the bookstore and you can put your work up. If you don't own the copyright, however, you can't do that. You have the right, the print, digital, adaptation, which is just another way of derivative works, sale, distribution, display, promotion. These are all parts of copyright. And so copyright can become a very big pot of things that are in there. And as you can kind of see how these concepts are all sometimes very, very hard to wrap your head around in a linear fashion because there are so many of them. And those rights, while this is very duplicative of the last slide, those rights can be split. That's an important concept, I think, to understand for everyone. Your copyright rights are a big bucket of different things that are all, they're intertwined, but they're all disparate. Well, you can also pull each one of those out as you're dealing with contracts with others, publishers, etc. You are never required in any situation where you have to give everything to anyone unless you're getting paid for it. You can say, oh, I'm just going to give you the rights to a print publication or just the rights to a digital publication. That's becoming more and more common, obviously. Foreign language, we talked about translations as being derivative rights. Audio, merchandise, film, TV, games, these sorts of things. When you are discussing contracts with someone and you are writing or you have a contract that you are thinking about entering into that it's for yourself, know that you, as you look through these things, you can pull off the pieces that are most important to you or that are most important to the others. And it's important to take an analysis in an individual way of these different aspects of what you are possibly giving away or retaining. They're all valuable, and it's very easy for a slick publisher or lawyer to just bundle this into a simple, everything, I want everything, when in fact you need to be aware of the individual components that you can essentially kind of force out of the agreement. So we have now, we talked about anthologies slightly, and this fits in, of course, with the fact that there are various pieces that can be pulled in and out of your copyright pile, your copyright bucket, so to speak. And so that's why I have this here to talk about. So if you have a contract language that would say Casey Creator retains the copyright for the contribution in the name of Casey Creator, and Paul Publisher retains the compilation copyright of the collective work. So the nuance here is that you can still own you would still own the copyright to your part that is going to be put into the anthology, and the publisher can still own the copyright to the anthology. So even though your work is in the anthology, so you have no rights, obviously, to reproduce the anthology. You have no rights to distribute or resell the anthology. The publisher does. So that is the anthology part of your, the ability to publish a non-exclusive license in an anthology would stay with Paul, but you, as the creator, would retain the copyright to the work itself. And that is an example of how you can essentially bifurcate various rights that you have within the copyright for a work that you have. All right, so let's talk about joint work, joint ownership. an example, again, I think I mentioned this briefly, but you're at a convention. One of you is an artist, one of you is a writer. You sit down, you're sitting there, you're spending your time there throughout the day, and you guys come up with an idea, and you think, you know what, let's put a comic book together. This would be great. You do what is it, the 5-minute comic book? I think Neil Gaiman started this 40 years ago or something. But the quick comic book that you sit together. Well, you collaborate, you come up with it. Well, if you have a joint work and you don't have a contract. Questions that come up is who owns the characters or who owns the character designs. So did the writer come up with the character, and did the artist come up with the character design, and who owns what? Who controls any adaptations in the future? About licensed merchandise. These are just a few questions that when you go and you collaborate, you need to be addressing in contracts. And so I know my example is a little silly. If you're sitting at a convention and you come up with a quick 5-minute comic book, you're not going to then sit down and start drafting contracts. But it's for illustration purposes. You are going to want to make sure that you have language in your contracts that will address joint work ownership if you are involved in any collaborations. So here we have a contract language. And these are taken from, there's an individual at the VLAA that provided me with a number of their comic book contracts that they've used. So a lot of this it's adapted from real comic book contracts. But as an example, this says all rights and character designs, costumes, logos, settings, and story concepts will be owned jointly by William Ryder and Isabel Illustrator unless otherwise stated in a signed written agreement. Neither party may license film, television, game, merchandising, sequel, or spin-off rights without the other party's prior written consent. Now, we're going to talk about this a little further, but there's a couple of issues that this illustrates, or a couple of issues that this is appropriate with. First of all, obviously, it's showing that now we talked about how you, depending upon whose contribution is what, you might not each have an equal 50% ownership in the work. Reducing it to a writing with a clause similar to this starts to get you there, where now there's no more concern or question who owns what. Both creators have essentially a right to control what happens with the work, regardless of which piece. So you don't have to be fighting down the road of who contributed that. Oh, I was the one that said that the hero should wear a jacket. Well, so I want that piece. And instead, you now have this written down, and you have an agreement that will help you with this in the future. The other, all right, I forget what my next point was on that. So let's move on from that. So now we're going to go back, and I know I'm jumping around here, but this is work for hire versus creator owned. If you have a work for hire, like we talked about, the company is going to be treated as the author. It shouldn't say may, that should say the company will be treated as the author. And the creator will receive payment. You're an employee or you have a contract, you're an independent contractor, you get paid, but you're not going to have any ownership over the creative work that you created. If it's simply creator owned, then of course the creator retains the ownership of the copyright. And if you have an agreement with the publisher will only receive the defined rights that you have in your written contract. So now, here is a clause that I want you all to be familiar with. And again, this is not something to memorize, but again, the idea today is to get you familiar with the concepts that you'll be seeing. And this is something that should be a red flag if you don't want your work to be a work for hire, because this is common language that you'll see. And essentially, it's a two-part clause. And at first, it says that the illustrator acknowledges that the artwork is going to be a work made for hire on the publisher's behalf. Well, I think that's straightforward and pretty simple. It stays right up front that it's a work for hire. However, you also want to look for this sort of what I would call, I suppose, sneaky language in here, which is something that we as lawyers do all the time because we want to, belt and suspenders and make sure that our contracts are enforceable. But this then goes on to say, to the extent that the artwork may not qualify as a work made for hire, the illustrator irrevocably grants, transfers, and assigns all right, title, and interest in the artwork, including all copyright, trademark, etc., through the world in perpetuity. So what you've got is you have one sentence there which has straight up says it's a work made for hire. You have a second sentence there, however, that says, well, let's say that fails. You still are going to give up all of your rights in this to the publisher. And this type of language is something that you want to be very careful that you're looking for if you're being asked to sign any documents for or any contracts with publishers or other individuals, because it is very easy to suddenly lose all of your rights in these types of things. And it's important too, because this is ownership language, not merely payment language, because it can be easily misinterpreted that that second clause is essentially just saying, oh, well, he's just listing what I'm going to get paid for, when in fact it has nothing to do with payment. This has to do with your ownership of the copyright. So work for hire, though, sometimes is inevitable. I mean, we all have to work for a living, right? There's probably a lot of individuals who are creatives both on their own time, but also have creative jobs. But the other thing is too that there's also times when you're going to be commissioned, and you're going to take jobs like this. There's times that you have to take jobs like this. So if it is a work for hire, and I was probably overemphasizing before now, an all or nothing type situation, but it doesn't necessarily have to be an all or nothing in the sense of the benefit or the rights to a creative. If you can't retain the ownership because for whatever reason someone wants you to do a work for hire and you say, okay, I want to do it, keep in mind when you're negotiating a written contract, when you're negotiating a contract, you can still negotiate for credit, portfolio rights, the right to be able to use reproductions of this in your portfolio, the right to be able to put this on an online portfolio, limited name or likeness use, giving you limited use of it, and approval over maybe any reputationally sensitive uses. So again, well, I'm going to create this piece of work for you. You're going to own it, but I'm going to say that you cannot publish it in certain publications, or it can't be used for political purposes, something along those lines. So again, this gets back to the concept of your copyright rights is a big bucket that pieces can be pulled in and out of as you're negotiating these agreements. So again, a work for hire is you're not going to retain the copyright, but you can still retain benefits for yourself as an artist. And on the side here to the right, we have some sample language that you might see in a contract. Isabel Illustrator retains the right to use the artwork in the portfolio, website, social media, convention displays, and award submissions after first publication. So essentially, the illustrator there is not going to get does not have the copyright, does not have the right to resell the work, does not have the right to use the work in a commercial way. However, they can still use it for essentially social media. If they're at a convention, they can put that up in their booth, and they're not violating anything. Obviously, award submissions are, of course, always important and sensitive to creatives. So these things can all be negotiated out separately. And again, this is going back, and this is belaboring the point, but I think, again, this is an important point, is that just because you're an independent contractor does not mean that you are the copyright owner. So again, we talked about the most common work for hire situation is the employee-employer relationship, and I don't think it's very controversial that if you work for Disney and you are tasked with creating something, the Walt Disney Company owns that, you don't. However, sometimes people think, oh, well, I'm just an independent contractor. I wasn't a direct employee, so they asked me to do it, but I clearly own what I've created. And that's not always correct. It always is going to be determined by the language of the contract. So you want to be careful with that, because you can find yourself in a work for hire situation where you lose your copyright rights, even if you are not a direct employee of whoever's asking you to create the work. Okay, we talked about this a little bit. Let's circle back around to it again, because I think this is an important concept. And this is, again, what you have to give with regards to your copyright ownership in a contract. And you're going to see these three terms over and over and over in any written contract. And again, an assignment is going to be a transfer of ownership of everything. That's giving it away, as in it is not coming back to you, and whoever you are assigning it to gets to do what they want with it. You've got the exclusive license, where a license is essentially giving someone the ability to do something for a period of time, either exclusively or non-exclusively. Think of it sort of in a way, you can think of it as a driver's license. We all have a right to drive. If we have a driver's license, that driver's license can be revoked if we either do bad things or become a terrible driver. Obviously, doing bad things doesn't revoke your copyright license, but it's a temporary circumstance situation. All right. Now, character and universe rights. Universe rights being the story, the world that you create when you create your works. And these are things that are important to be addressed in contracts that involve comic books and comic book creators. And it's essentially, when I say newly created characters, you can have a shared world that new characters spring from down the road as time goes on. It might not necessarily be a character that you personally created. It might be someone who was working on your world to create a character. Who's going to own those created characters? Who owns the visual designs, the costumes, the logos, the settings? We all know logos, designs. These change over time. They change both as work matures. They also change just over time as society changes. So who can continue to own future modifications of that? And then again, also, can the publisher who is publishing your work with these contracts, can they use the characters anywhere? Can another writer use them? Can the publisher have other writers ask other writers to work on your world? And what kind of value do you get on this? Now, these are all questions again, and with the theme of this talk, where it's issues that you need to spot when looking at contracts. These are all questions that you should be asking yourself if you're dealing with a publisher that wants to start publishing a shared world or a world that you've created in your comics. Below is an example, and I promise you, this is the only case law we're going to talk about. I don't want to bore you all, but there's a case, DC Comics versus, I'm going to say Tal, I don't know how you pronounce that, but essentially, Tal, this guy, had gone out and he started making physical Batmobiles and selling them. And he was creating, it was a work of art. I mean, he was an excellent auto guy. He was creating these, he was selling them, and things were going great. Well, DC Comics didn't really like that. And so that case, essentially, DC Comics sued them and said, you can't be selling these, this is ours. And this is essentially one of the main cases that came down with the fact that as these different characters evolve, and the courts did consider the Batmobile a character in the from the Batman universe, that these are derivative works that are going to be owned by the original, the copyright holders, and that other people can't just go out and start essentially ripping off the ideas, even though he was taking an idea, so to speak, and turning it into a real world thing. It was considered as part of the characters and of the designs, and essentially this is essentially showing that you have to account for these things as you're dealing with these contracts for your comics. Now, as an aside here too, and I catch myself doing this because it's very easy as an attorney to do this, because I love to sit down and write very long contracts because it makes me look very smart. And if I can write you a 100-page contract, man, my clients are impressed with that, right? But the thing is that I realize I am overly complicating everything in every situation, probably. I want you to kind of take my comments and my remarks again as it's always looking at these contracts in a totality of circumstances and what's the most important thing to you and what are the actual situation that you're facing. Because no, I'm not going to bring someone in who wants to have a book in an anthology and we're going to deal with every single one of these issues. This is more of something that you need to just keep in mind as you deal with this, as your career goes on. These are things that you might see, you will see, and it's important again to always to discuss these with an attorney so they can help you issue spot and decide what are the most important things. Because I know that a lot of you are probably sitting there thinking, this guy's an imbecile. He's telling me we're going to make a 5-minute comic and have 1,000 of these issues involved in a contract. And I get that. I get that. But it's easy for me sometimes to be myopic and just see, want to have everything possible in a contract. So as with everything in life, you have to be realistic about what you're doing with these. So now on to publication rights, because again, especially as comic book creators, probably the people that you're going to initially deal with the most often in dealing with written contracts is publishers. And of course, the publishers most likely too are probably going to come to you with contracts already written, because they do this is what they do every day. So again, as you're looking through this, to keep hitting on a theme, your ownership and your rights in a copyright can be pulled apart into almost an infinite number of ways. So if a publisher is asking for rights to publish your work, take a look, keep in mind, what is the deal and how much do they really need? Are they asking for a single issue that they can distribute? Or are they asking for everything? Do they want digital editions? Do they want to do graphic novels or compilations of all of my work? And do they really need it? If they really are saying, well, I just really want to publish issue number 1, but let me have all of it, because you never know. Well, this is something that should raise a red flag for you as you're dealing with these individuals, because all of these pieces are valuable to you to parse out down the road, and you don't want to be giving away too much upfront because you either didn't know to ask for it or that the publisher is just simply trying to get as much as they can from you. Because the worst thing that can happen to you is they only want to publish a single issue, but they figure out a way to contract for everything you've done. And then next thing you know, that single issue takes off, and now you don't have the ability to go resell the rest of your work to a better publisher or a better deal as things go. So, all right. We have here is a broad all media grant, which is again what I was sort of discussing about making sure that you hold back when appropriate what you actually own. If you have a contract here, and again, these are some real world examples, just with obviously the names changed, but Paul Publisher has the unlimited right to publish the artwork in whole or in part, individually or in combination with other material in all media form and formats now known or hereinafter developed, to prepare revised versions of the artwork and to make alterations, modifications, in addition that Paul Publisher deems appropriate. Now, obviously, this is an extremely broad paragraph that lets the publisher essentially do whatever they want with your work, and you're not pulling out any of the individual pieces that you might use down the road. So, is there anything wrong with that contract language? Of course, there's not anything wrong with it, but you're giving a lot up when you do that. So just go into it knowing what you're giving to them. Now, if you wanted to try and narrow it down, you can essentially have additional language added, or you can change things. And here's an example of another one that is a better example for a narrower publication-only grant, which would essentially say that Paul Publisher may reproduce, publish, distribute, and display the artwork solely as part of the example comic in print and digital editions during the term of this agreement. So right there you see it limits the time, in time, how long they have. It limits what format it is being produced in. Now, it's still print and digital editions, which is large, but still, it's still narrowed down. Paul Publisher may only make technical formatting, cropping, or production changes reasonably necessary for publication, and cannot make material artistic, narrative, character, or reputational changes without Isabel Illustrator's prior written approval. Again, the previous language that we read, which allowed the publisher to change anything they want. You have every right, when you're negotiating your contracts, to require that you have input on the major issues, and that you're only allowing essentially technical changes that have to be made for the purpose of a publication. For example, if something needs to be cropped, pardon me, slightly to fit a page, things like that. That can be done, but they can't make any major changes without your input. Then additionally, you can also add in that all rights not expressly granted are wholly reserved, including any electronic usage, any rights or usage, and all rights and sketches, comps, or other preliminary materials. You can always, the beauty of a written contract, you can always continue to define what you are giving and what you are keeping for yourself. Again, this is going to refer back, pardon me, I'm sorry. This is going to refer back to those questions that we talked about, those 4 questions at the beginning, which is, of course, who owns what, and you want to make sure that you retain ownership of the things that are important to you, or at least retain as much of the ownership as you can. Okay, so publication terms are defined. Now we're going to switch gears here a little bit. So this is a section that is important to put in a contract for many reasons, but this is going to be defining what is required by the publisher. So is publication required? That's on the top, because that's probably the most important, because I have seen real world situations where a creative will create a work and they will contract with the publisher or someone else who is going to produce the work for the general public. They might make that contract and for whatever reason never move beyond the contract. They still pay you, but there's no publication required, and if there's no publication required, or this isn't defined in your contract, your work now is just stuck in limbo, and there's nothing you can do about it. If you gave them a 5-year term and you don't have a required publication clause, then they can just put it on the shelf, and your work will never see the light of day until that term expires, and there's nothing that you can do to force it. However, again, if in your written contract, if you can have, if you could put publication requirements, deadlines, formats, things of that nature. If the publisher does not do what they say is defined in the contract, you now can have leverage to force them to do that. Your work will now not be end up in a black hole, never to be seen, and out of your hands. And then again, other common terms in this sort of a format or a section would be whether there's a minimum print run. I mean, obviously that's going to be highly dependent on the situation and important. Digital editions, pricing, and then furthermore, if you're going to have these terms, you're going to want to make sure that what that means by in print, because I've also seen situations where they have a publication requirement and they just simply throw it up on their website because, well, we're not going to be able to do it for real, so we'll just that and we're going to claim that's in print, right? So if you can define that ahead of time, you avoid the situation that lets them weasel out of doing what they should do, which is essentially producing your work for the public to see and for the world to see. Okay, a media rights reservation, and again, we're talking about how in your written contracts you can define what your rights are, what your ownership rights are, and what you're holding back. You can do things, especially if you're not in a position or you're not interested in, well, I don't want to go through all the different aspects of what could be used. We could just put in an all-motion picture, television, animation, streaming, podcast, game. Dramatic and allied rights are reserved unless granted in a separate written opinion or purchase agreement. So what this is illustrating is that you don't have to necessarily define every single thing in the contract that you might have. You can refer to what will have to be agreed to in totally separate contracts. And that's just as legitimate and a much easier, streamlined way to do it, especially at the front end. Now, again, if you're Marvel, you're going to be defining every single one of these in hundreds of pages worth of definitions. If you have created a brand new work that you're not sure what's going to happen with it, you can just simply put something as simple as that in, which will essentially alert everyone involved in the contract that I'm not giving you any of these rights, and we can discuss this separately if you're interested in them or if it becomes important or necessary. So I'm going to start moving a little faster probably here. Merchandising and crowdfunding rewards. This is kind of a new area. I've started putting this in this talk because it's becoming very popular to crowdfund artistic works, comic books, things of that nature. When you do that, there's essentially two ways to do it. You could do it yourself, which of course avoids all of these issues because you're doing it yourself. But there are organizations, companies, and publishers out there who will essentially run these sort of crowdfunding campaigns for you. Well, when you do this, this is an individual, this is a publisher essentially that you're going to be entering into a contract. And you're going to want to make sure that you also are addressing what is going to happen with sort of the rewards, the things of this nature that happen in these crowdfunding campaigns. So, because many times it's okay if you commit at this level, you get the physical book published, you get a digital book published. Oh, and you get these rewards, a coffee mug or stickers or what have you. Again, keep in mind, as we talked about the definition for derivative works, these are all derivative works. These are all rights that you will maintain and keep if you own the copyright, and you want to make sure you're controlling what happens with them and how they are parsed out. So you want to make sure that those issues are addressed. Sublicensing is probably a bigger topic than needed to be put in here. This is just simply whether you're going to allow a publisher to not only publish your work and use your work as they see fit, but then be able to go out and essentially transfer that copyright in a licensing format to others that you are essentially cut out of. So this is not a very popular, or I would say I don't see this a lot in these type of contracts, but sublicensing is something that I did want to point out, that if you see that term, if you see a clause, a sublicensing clause, pay close attention, because what you're essentially doing is you're letting someone else decide what they can do with your contract. Okay, money, this is probably the most important thing, right, for everybody. And I know Steens had asked me specifically to make sure that we talked about this. So this is, there's two ways to be paid. Well, first of all, let's make sure that we're understanding that this is if you are essentially doing work for hire. This is work for hire situation. These are not you're doing it yourself. This isn't a publishing contract in the sense that a publisher says, oh, I'd like to publish your book. Let's negotiate a rate or a payment for that. This is someone says, hey, I want you to create this work for me as a work for hire. And there's two ways essentially to get paid. There's what's called a page rate, and then there's an advance against royalties, and royalties. So the page rate is straightforward. It's essentially a fixed amount per page. It's a very predictable way of being paid, and it's going to include really no upside outside of the amount that you contract to do. So, for example, someone would say, you know what, I need 5 pages of this particular comic drawn and written and penciled. So I'm going to pay you $500 a page, and you're going to do the 5 pages, and you're going to get the money. You're going to get the $2,500 if I'm doing math correctly, and that's that. And then you're done and nothing else. Now, advance against royalties or royalties is essentially, it would be the publisher or the person who is trying to get you to do the work for hire is not going to pay you per page or per hour or the time that you spend. What they're going to say is, we are going to pay you a recoupment from the royalties we make. So basically, from the money that they make off of your project, they will give you a percentage, is typically the way you see it, of that profit. Now, typically, if you can get an advance, and an advance is essentially going to be an upfront payment against that. So they might say, you do this work for me, I will give you 5% of what we make off of that, and we'll go into this in a little more further, but I will give you an upfront payment of $1,000. You're going to ultimately be paid 5% of everything that's made from this project. Now, when you get that $1,000 up front, that is usually recouped from the royalties, meaning the first $1,000 that you would make from the royalties you don't get because you've already gotten it. And then after you have earned out that $1,000, you will then continue to make that 5%. Now, the page rate example is pretty straightforward and simple, and I don't think it's very complex. The publisher agreed to pay $150 a page for a 5-page comic, total $750. Payment will be paid upon completion of the pencils, and then the second half will be paid upon final art delivery. It's very important that that there's a lot of these terms though on the right side. That contract on language on the left is very simplistic and probably doesn't do the job because it doesn't include a payment deadline. It doesn't include any details about revisions. It doesn't include any details about a kill fee. And a kill fee is that the project, I come to you and I say, I would like you to do those 5 pages of the comic, and you draw 4 of them, and then I call you up and say, oh, you know what, the project is dead. It's killed, so we're just not doing it anymore. Well, there's nothing defined in that language on the left as to whether you're going to get paid for that or not, or did you just waste your time doing the first half or first 3/4 of that project. Late payments are usually, late payment language is usually included in a contract about page rates. And then, of course, the rights granted, which typically, like we said, is going to be a work for hire, but it should be defined in the contract. Now, if we do the page rate, there's additional language we could put. So, and this is going to illustrate those points that I was making as to what you should usually look for in your contract for a page rate contract. And that would be, you would add in payment is due within 15 days after each milestone. Milestones, if you remember, were the when the pencils were done versus the final delivery, there were 2 milestones. So you would essentially get, you finish the 1 milestone, you get your 50% within 15 days of that. If they don't do it, you then can go back after the publisher or the individual commissioning the work and force them to pay you through the contract language. Revisions beyond 2 rounds or revisions caused by a change in direction after approval of pencils will be billed at X dollars per page. If the publisher cancels the project after work has begun, the illustrator will retain all payments already made. So, for example, the first milestone is reached, you get your money, but they kill the project. Well, you don't have to return that money. And you'll be paid a kill fee, which is also an additional fee usually for your time. And because, again, when you're doing work for hire, you are by definition not doing other work that you could be doing. So you are spending time on one thing. So it is right to be compensated for the fact that you didn't get to do a personal project or a project for a different individual. And then plus payment for all approved and work completed before cancellation. So this is just, again, language to kind of tune yourself to, that if you're looking at page rate, you're going to want to have some of these details in there. Now, let's talk about an advance against royalties example. So we have here, Paul, publisher, will pay Isabel Illustrator as an advance against Isabel Illustrator's earnings from all sources under this agreement. The sum of $42,000 payable in installments upon signing, delivery, and acceptance of progress materials, delivery and acceptance of final illustrations, and publication of Paul Publisher's initial edition of the example comic. But if we go over here, so that's basically just a very basic language for this type of a situation of an advance against royalties. However, this is very bare bones and should be fleshed out. And for example, here we talk about some of the other issues we talked about, which is the advance is non-returnable, except in the event of Isabel Illustrator's uncured material breach. So that would be if the publisher cancels or the publisher messes up, you don't have to return it. If you as the artist mess up, well, that's a different situation. But that's if you just said, oh, I'm not going to do the work, or you didn't follow instructions, or you didn't follow what they wanted. And then the advance will be recouped only from Isabel Illustrator's share of royalties actually earned under this agreement, and will not be cross-collateralized against other works, formats, editions, licenses, or projects unless expressly stated. So that's essentially, again, further defining that they're not going to get to start saying, well, we canceled this, but we're going to now take money from another project you're involved with just to pay it off to sort of, so we all come out equal. These are things to protect you for the money that you're getting. As an aside, I thought it was a really good idea to change these names with this alliteration, and they are a pain to be saying while I'm standing up here in front of you. So I apologize about Isabel Illustrator and Paul Publisher. Anyhow, so now, royalty base and net profit issues. And again, that language we had before was very simplistic language. There's a whole host of other questions that you're going to want to be asking yourself and looking to if you're dealing with getting paid essentially on a royalty basis. And these are the things that you're going to want to have defined in a contract for you. So when we're talking about the money that they're making, because remember, your royalty is going to be a percentage of some number, Well, where does that number come from? Is it the cover price? Is it the list price that the publisher puts that out? Maybe it's the wholesale price that the publisher is selling it. So do you get 5% of the cover price at the bookstore, or do you get 5% of what the publisher sold the book to the bookstore, the wholesale? What kind of receipts are you going to get from the various parties who are involved? Net profits. Net profits is a big one, because net profits can be manipulated all over the place. You've probably all heard of how Hollywood has their wonderfully creative accounting, and there's never been a project in Hollywood apparently that's made a single dime, because they figure out a way to give royalties, but then have so many expenses and deductions that it's always comes in at a loss. So you want to be able to control what expenses and deductions are allowed. Are they going to be able to deduct the salaries of the president of the publishing company, or are they going to only be able to deduct the expenses of actually publishing and creating your work? These need to be well defined in order to be able to stay on top of what you are owed in a royalty and how creative they are allowed to play games with the accounting. And then how often are statements issued? Are they going to give you a statement as to the net receipts, the net profits? Are they going to be giving you that statement once a year? Are you going to get it monthly? Are you going to get it quarterly? So that you can stay on top of what's owed to you. And then finally, audit rights. Audit rights are huge because, again, as we talked about how they can play all kinds of games with their deductions and expenses, do you have the ability, if you're not getting paid and this becomes a very valuable asset, are you going to have the ability to send in your own accountants and attorneys and force them to turn over their books for you to look at and see what they're doing and how they're coming up with these numbers? Because it's one thing to agree to a percentage of royalties. It's another if you're trusting just me to tell you what I made last year on your work, as opposed to me knowing through the contract language, oh, you get to come to my office and start looking at my numbers and my pieces, my accounts. It's going to make me be a lot more honest in what I'm telling you, and it's also going to keep you aware and on top of what you're rightfully owed for your work. So here's another variation on royalty payments. This is the royalty pool example, and this is probably more prevalent in the comic industry than other industries, and that's because you have so many anthologies, because anthologies are such a large part of the publications, and so you might have to deal with all of those other issues, but then you have what's called a royalty pool, which is that they're going to say that all the artists share in a percentage of the gross receipts, or however it's defined. So you want to make sure you're aware as well of that, because you're not getting 10% here. You're getting 10% divided by the 7 authors that were published in the anthology. This is another term you might see in contracts if you're working on a royalty basis. Okay, so we talked about this briefly, because when we were talking about you only get copyright with fixed with works that are put into a fixed medium, right? So if you have an idea, you have no copyright. You have no copyright rights in concepts, in ideas, in things that you just throw out there. So obviously this is problematic, because there are lots of times that you're going to be collaborating, possibly, especially in the comic book industry. You're going to collaborate and you're going to be throwing out ideas. You're going to be throwing out concepts, whether you're pitching to a co-creator, whether you're pitching to a publisher for, hey, do you want us to move forward with this project? These types of things. And without any copyright protection, there's really no mechanism that you have in general to protect that. But that's a false statement, because what you can do, in addition to your contracts with publishers, your contracts for publishing comics, your contracts with other creators, you can have collaboration agreements. So you don't get copyright protection, but you can have contractual protection for collaborations. So if you find that you're going to be entering into a situation where you're going to be throwing out ideas and there's not going to be anything necessarily written down, or there's not anything that is specific, you can begin to enter into what would be a collaboration agreement, which will define the relationship that you have with either your co-creators or with a publisher. So, and they take two different forms, because if we're talking about a publisher, you're going to want to have an agreement that says these ideas are all mine and you get to do nothing with anything that is said here today. And then you get to go in and you can be free with what your ideas are. You can be free with your pitches. And even though you don't have a copyright in that, you have a contractual right to that being protected. You might also know this from an NDA or a non-disclosure agreement. These are different terms that are used in different situations. But then also this can also be done with a co-creator, where you guys sit down and, how many times have you spitballed with someone and you come up with some great ideas, but nothing really comes of it, right? Well, and then you both go your separate ways. Well, if you threw out 90% of the ideas, you might want to think about having some sort of a collaboration agreement so that your co-collaborator knows, okay, you can't just go out now and use all my ideas 5 years down the road because you've decided that it's a better idea than that. And if you don't have a collaboration agreement, like I said, and you haven't reduced it to a fixed medium, you're going to have no protection, and your co-collaborator can take those ideas and do whatever they want. So this is another use of a written contract that will help define your relationship and what you can keep an ownership of. Again, going back to that slide with those 4 questions we talked about. Okay, portfolio carve out. We've touched on this a little bit again, and I know I've repeated myself 100 times here, but copyright is a big bucket of very discrete things that can all be pulled out. So keep in mind that as you're doing this, your professional reputation, your marketing, these things are very important. So you want to make sure, if it's important to you, that you do keep in your contracts the ability to carve out the ability to use your work for things such as a professional portfolio, a personal website, social media, for example, grant applications, award submissions, conventional materials, these sorts of things, because these are important to you. Now, these are things that you're not going to be able to go to another publisher and say, hey, I want you to pay me to publish this. But these are things that can be very important to your professional development. And these are things, as you're not only negotiating contracts, but as you're looking at contracts, these are important issues. And at the very bottom, the thought that sums this up is that exclusivity can coexist with self-promotion. So you can give a publisher exclusive rights to your work, but still carve off some of what you need for your own self-promotion. Okay, credit. This is another important one, obviously, again, for your reputation, for your marketing, for your, just in general, your career. You can still give exclusivity. You can still let individuals have essentially complete control of publishing your work for a period of time, but you are allowed to and should be encouraged in your contracts to make sure that you specify how you are going to get credit for the work that you're doing. You can get down to specifying the exact wording that they use, what exactly your role in it was. Do I want to make sure that I'm credited as an author or a writer? Which term would you prefer? You can do that. Is there going to be credit on a cover if this is published? Where's the credit going to go in the interior of the publication? If it's digital, how does that credit work? Where does that show up? Is it going to be embedded in the actual artwork itself, or is it separate in an attached post? These are all issues that you should be keeping an eye out as you're creating these contracts. In addition, and in the very bottom too, it's always important. We really haven't talked about this much, but in addition to setting up all these rules, you also have the right in a contract and should make sure to define the remedies if the other side does not follow the language of the contract. So remedies meaning if they don't give you credit, what can you do about it, and what do they have to do about it? Whether that could be compensation or pulling books off the shelf and reprinting them, whether that be changes. You can do anything you want, but it's important to keep an eye out for that too in your contracts. Creative control and approvals. Again, I mean, we probably don't have to talk too much about this, but again, this is something else that you are allowed and should be encouraged to include in any contracts you're involved with, so that you have control over approvals, because you don't want to be giving others a license to alter and change your work in a way that you do not agree with or does not fit the artistic vision. And of course, the approvals can be, pardon me, over all sorts of things. You know, the scripts, the artwork, the covers, the titles, any editorial changes, it's up to you. Now, two terms that I put at the bottom, just to point out, is you're going to see sole discretion and not unreasonably withheld. These are the way they're going to define your ability to approve or control. The one term you're going to see is sole discretion, which means you have the absolute unilateral authority to say yes or no. Not unreasonably withheld, in the other hand, means that you have the ability to say no, but you can't be unreasonable about it. So if they say, oh, you know, the cover we were going to print in this color blue, but we have to do it in a slightly different shade. Well, you can't unreasonably say no just to be a pain if it says not unreasonably withheld. So those two terms of art are something to be aware of in contracts. And 30 or 30?
30 minutes.
30. Oh, that's more. Okay, I thought I had 1 minute. Good.
No, you have until 8:30. So.
Okay, very good. Perfect. I can't believe I've only had one person walk out on me. It's all right. So let's see. Oh, deadlines, revision, and kill fees. This sort of falls. This kind of goes hand in hand, and a lot of times you'll see this close to those terms that we were talking about with the required publication, the terms about publication, and again, things that your contracts can and should address is essentially delivery dates. Delivery dates meaning when. Typically, that refers to not when the published work is going to be delivered, but when your artwork will be delivered to the publisher. Revision rounds, this is always a sticking point, very important. You start working for someone or with someone, especially if it's a work for hire, you do not want to get sucked down into a situation where your 50 revisions later are still making, you know, $150 a page, and they've now taken up the last 6 months of your time because they keep coming back with the revisions. You want to have both definitions in there about how many revisions can be requested, to what extent they can be requested, and if they exceed a certain threshold, that you usually want to make sure that you're going to be compensated for that. Because again, you cannot allow yourself to be sucked into a situation where they can just give, well, the contract says I can ask you to revise it, and then next thing you know, you've spent your entire year on a project that you should have spent 5 hours on. And again, below that, extra revision compensation. Late delivery. This is, of course, unfortunately, usually will cut against the artist, the creative, because the delivery has to do when you're going to deliver your artwork. But that's important to put in there because you want to know what the penalties or the terms are for a late delivery. Editorial response times, now that's back on the publisher usually, or the individual who's asking for the work for hire. You want that defined so you know what the expectations are. If you don't hear back from the publisher in 3 weeks and they have to respond in a week, well, you know you're off the hook and you move on to another project. Kill fees, we discussed that previously. Payment for approved partial work we've talked about. And then there's the reuse of rejected materials. That's not very important a lot of times, but it's something to keep in mind that if you feel that you're in a situation where they might reject your material, you want to sort of have it clear who has the rights to do what with that rejected material, especially if it's a work for hire. Because remember, work for hire, you don't have the copyright. The individual or the company that essentially commissioned it has the copyright, therefore the ability to do whatever they want with that work. Okay, warranties and indemnity. You're going to see this in every contract you sign, whether it's for creatives and comic books or practically anything else you do in life. And these, essentially, this is just fancy language for you're going to make promises to the other side that something is true and that if you're not telling the truth, that you will be liable for that. So essentially, when it comes to a contract for comic books, it's going to come down to, they're going to ask you to essentially promise them that what you have produced for them is an original work of art that you haven't copied something. They're going to ask you they're going to ask you to promise that you have the actual authority to grant the rights, that you haven't already previously given this copyright to someone else, and that would be an infringement on that. They're going to ask you usually to promise that you're not defaming anyone. They're going to ask you to promise that you're not violating anyone's privacy or publicity rights in it. And you're going to see those. Probably any publisher that is worth their salt is going to have these types of terms and requirements in there. They're nothing to run from. They're something that you certainly want to pay attention to, and you're going to want to abide by them. But hopefully everybody is abiding by those things anyway, because this is not a crazy request. And it's also, though, important to know that if you do not have the authority that you're saying and promising you do under the warranties section, that you could be liable, meaning you could be owe damages to the publisher. So if you were to make some great comic book after tonight's talk about what a terrible speaker I am and it makes me look like a horrible person, and you violated my privacy rights, but you tell the publisher, oh, no, I'm allowed to say, that guy told me I could say all kinds of bad things about him. Well, then now if I go to the publisher and say, wait a minute, so they might come back to you and say, oh, you lied to me. You didn't have the right to reproduce that guy's image. So that would be sort of the situation that we're talking about with that. And again, these are going to be in almost every contract. They're nothing to be worried about or run from, but you do want to read them, know what you're promising, and make sure you have the ability to promise what you're promising. Terms and territory, this is pretty sensible. Again, you can divide up your copyright. You can give copyright for a specified term. You can give it for the life of the copyright. You can determine the territory, worldwide or limited territory. When it's worldwide, something that's always fun to do is, I always use in my contracts, and I think a lot of people do, we always say the known universe, because you just never know what we're going to discover with all the aliens that apparently are around. But you want to see there's going to be terms worldwide, limited territory, known universe. Those are going to be language that's going to tell you how wide of a right you're granting to a publisher. Different languages, a French version, a Spanish version, an English version. Obviously, you have the right to divide that up, and you can specify that. And then, of course, renewal terms are commonly put in where a publisher might say, I want to write for 5 years, and then I have the right to renew it automatically for an X percentage more money for another 5 years. That you're going to see that sometimes in your contracts. Reversion and digital removal. I'm again trying to, for time. This is essentially, you should, if you are concerned, you should always have language that will give you the right to request a publisher pull down your work if they are not abiding by the terms of the contract. So this is something that gives you the right to essentially put them on notice in writing that they're not doing what they're supposed to do, and that they are required to remove your work from the internet and from any place else in any kind of distribution, etc., that they're doing. Termination for breach, non-payment, non-publication. Again, I know we're talking about these. We've already talked about some of these issues, but your contract should address what counts as a breach, and basically a breach is if they don't abide by the terms of the contract, they don't do what they said they would do. Now, it's very common, and this is another term to be aware of in a contract, is there's something called, a concept called cure periods. So many contracts are written in a way that the parties have to do certain things. And if they don't do certain things, that doesn't necessarily mean that immediately everyone gets to start suing. There is many times a cure period, which is essentially, oh, you didn't pay me like you said you were going to do. You have 30 more days to do it. That'll usually be defined in a contract. There'll be a cure period. So you want to look at that too, because that's going to be important both for your obligations, but also on a publisher's obligations towards you. If they owe you money or they have to do something, you have to know, are they given sort of a grace period, some leeway in there that they can create cure? And many times those cure periods also are only triggered if you, in writing, let them know that you're aware that they didn't do what they said. So you want to be familiar with that as well. Now, non-payment triggering termination, this is a common thing that can be found in contracts where if they don't pay you, then you can have a clause in there that just terminates the contract. You know you're off the hook for anything in the future. But you want to know that, because if non-payment doesn't trigger a termination, well, you don't want to suddenly stop doing what you're supposed to be doing, because now you've also breached the contract, and now we get to have a big fight with all the lawyers. What happens to delivered work, what obligations survive, those are just themes that have been throughout the talk here about what your rights are in your with your copyright and with your work. Okay, enforcement. This is probably, well, I think I've said this 10 times, so now you don't believe me, but this is probably the most important thing in the world, because contracts come in all kinds of different levels. And as you can imagine, I've mentioned there's Marvel contracts worth hundreds of millions of dollars, and there's contracts for $200. And if you don't have an attorney's fees or a cost provision in your contracts, and you have a contract that is worth less than $50,000, you have a worthless contract many times, because the way that you're going to enforce a contract, ultimately, if the other side refuses to abide by the terms, is you're going to have to go get an attorney, and you're going to have to proceed in a legal manner against them. If you come to me and you say, I would like you to sue this guy who's not paying me, and how much does he owe you? He owes me $1,000. Well, that's going to cost you $40,000 in court just to be able to get through the process. If you have an attorney's fees and a cost provision in there, this now means that the publisher realizes, oh, I didn't pay them. Oh, they're suing me. Not only am I going to have to pay them the $1,000 I owe, I'm going to have to pay their attorney's fees and all the costs they incurred to get to court. It gives teeth to the contract, because I can't tell you how many clients I have unfortunately had to turn away that have absolutely 100% legitimate claims under contracts that they would win dead to rights, but they have absolutely no way to use the legal system because of the costs involved. If you have attorney's fees and cost provisions in there, now you can do that, because the rule is, I should have prefaced this, the general rule is that if you are suing somebody, you cannot recover your attorney's fees unless there's either a specific statute that allows you to, or if you specifically are allowed to by the language of the contract. So if you have a verbal contract, obviously you're not going to have attorney's fees and cost provisions. If you have a written contract that doesn't include an attorney's fees provision, you're going to be in a situation that unless that contract is worth a certain amount of money, it's not going to be worth your time to go after, because no one is going to spend $30,000, $40,000 on an attorney to bring litigation to be able to recover $1,000. I mean, obviously that makes no sense. The other benefit, though, of having that attorney's fees clause in there is you might have a publisher or someone who wants to be a bully and says, well, it's $1,000. What are they going to do about it? They're not going to do anything about this. I'm just not going to pay them. Well, if there's no attorney's fees provision, they can get away with doing that. If there is, they say, oh, wait a minute, my costs now just went from $1,000 to $1,000 plus everything it's going to cost them. So that's important, very important. Notice requirements, very important to always pay attention to. These are a hidden trap in written contracts, that you might be required to give notice to get payment, or you might be required to give notice if they haven't complied with the contract. Those requirements might be, you need to send a certified letter to a certain address within a certain number of days. Make sure you're always aware of those. Whenever I have clients who come in, I always like to take their contracts, and if they have any notice requirements, I will either highlight them or give them a separate piece of paper that says, these are your requirements under here. Keep it with your document so that you know if anybody starts to have a dispute, this is what you need to do in order to play by the rules and set yourself up in order to win. You might also see arbitration or mediation clauses in there. So we just talked about litigation, and litigation can be ridiculously expensive. You also have the right to ask for arbitration or mediation, and that can be defined in there. Those are essentially more informal ways of dispute resolution that doesn't require going to a judge, going to a court. I will tell you, however, that arbitration and mediation in the modern world has gotten to a point where it's almost as expensive as litigation. It is a little more streamlined. The benefit you get from arbitration and mediation typically is privacy because it's not public record what's happening. But you also want to pay attention to that because those might be the ways you are forced to resolve a dispute. You might not be allowed to go to court. You might have to be mediate or arbitrate based on the terms of the contract. So that's a clause. And these clauses, these enforcement clauses, these are always kind of usually at the end of the contract in that boilerplate that by the time you get to this page of the contract, no one can pay you to read another page of this nonsense. And that's when you have to pay extra close attention because a lot of these things can really affect down the road what your rights are. And then finally, there's jurisdiction clauses, things like that, where the dispute can be resolved. This is another one that gets clients a lot. And it's a shame, but you go in our modern world, we're all across the states, multinational. If you deal with a publisher, if you're going to contract with a publisher, let's say who's in California or New York, and they're going to have a lot of times in there that the only place that you're allowed to sue them or to go after them is in New York or California or whatever state they say. And again, it doesn't in any way stop you from having your rights under the contract. But from a practical standpoint, if you have to hire an attorney who then has to hire an attorney in California that is going to be litigating something for you, it makes it that much more difficult. So always be aware of where the dispute resolution is going to take place. Sometimes it's not specified, but if it is, you're going to be limited to that. I had a client come in, it didn't have anything to do with comics or art, but a client came in the other day, he had signed a contract, he has to sue them in Wyoming. And so now it's not worth his time to go after, so he's out of luck on that. So that's something very important to watch. Now, this is just sort of a quick recap. I feel like I've repeated myself 100 times, so hopefully this isn't one too many. But, top red flags to look for. Remember, who owns what and what your rights are. Always be concerned about all rights grants, anything that's granting all your rights. Remember, your copyright rights are a bucket of discrete parts that can be disassembled and assembled at will. Essentially, I know why I didn't think this earlier, it's just like Legos. You got, 100 pieces in there, you can all put them together into one cool thing, or you can have them all separate. You want to look for, again, work for hire clauses. You want to be careful with that, especially when we talked about earlier tonight, the independent contractors. Hidden assignments. This is essentially, again, you're looking at these long contracts sometimes. You want to make sure that you're aware of everything that is being assigned out from you. Back to that question, what do you own and who owns it at the end? Media, merchandising rights without any separate pay. That's, again, going to be just bundling things without pulling them out. When we're talking about royalties, anything that's undefined is regarding net profits. No audit rights. These are big, important issues. No publication obligation. We talked about that. That's very important for you because you're not creating work to bury it on the shelf or in a drawer of some publisher. You're creating your work for others to see. No reversion rights. Essentially, reversion rights are essentially at the end of the term or at the end of the period or the end of the license that what you get back. You want to make sure that those things are well defined. Broad indemnity. So we really didn't touch on that, but this is. I'm going to skip that topic for right now as we get near the end. And then not having a collaboration agreement. Again, we talked about the dangers of if you don't have your ideas written into or created into a tangible work, you're not getting copyright protection. So you want to make sure that you've got some sort of a collaboration agreement to protect yourself down the road as you work in a collaboration to create your works. So here's the other this is, I think, the final point, and then you guys can ask me whatever you want. But the comic book contract essentially needs to be looked at as a long-term rights management document. This is not just a short-term payment agreement. It's not just how much am I getting for the pages. This is your rights with relation to the work that you're created for the long term. Copyright currently for anything that is produced after 1978. I'm probably the only one here who could have produced something before 1978, is 70 years, or the life of the artist plus 70 years. So when you create something, you put something on a piece of paper, it is now yours everything involved with that is all those rights are yours and you own them all for your entire life, plus your heirs get the ownership for 70 years after that. So this is why these contracts are very important, because they can have very long-term consequences. And you need to always understand that when you're signing a contract, what are you giving away? Because you're always giving something away. You're getting something back. You're getting paid, but you're giving away ownership of your work. You're giving away control, credit, future upside, exit rights. All of these sorts of things are very important that you pay attention to, because the main goal is for you to keep the fruits of your labor. And, oh, well, they put it at the end. I told you I'd go back to that slide, but here it is. This is the VLAA contact information. Again, I can't encourage you all enough to avail yourselves of their services. It's a great organization, been around for a very long time. So, take a break, or take a breath, I mean. I appreciate you all actually listening, pretending to listen. So I'm here for as long as you need me for any questions you have, and thank you for your attention.
We have a special microphone if you want to ask a question. So, anyone?
First off, thanks for the talk. That was really great and helpful. So I think a lot of creatives are really anxious about how artificial intelligence is transforming creative work and all these industries. You know, we're seeing the largest copyright settlement payout between a group of writers and Anthropic, who owns Claude, right? I think it's like 1.6 billion, which is crazy.
Right.
I'm curious to see whether or not you have been seeing any sort of like increase in clauses that address like AI, generative AI, you know, either from publishers or publications or creators.
Right. So let's start with, because there's multiple ways to approach that issue, and it's a very important issue, especially to creatives. So the first aspect is the fact that others are using your work to educate, or I'm not a tech guy, so excuse all the vocabulary, but they're teaching the AI how to think or do what it does using your examples that you have created, that you own the copyright for. So this is an area that is a quickly evolving area of the law, like you just pointed out, and it is just being addressed right now. And so I do not have any sort of statement that I can make on that, because it's still developing, and I'm really not sure. Because the issue becomes with that is, as a sole individual creator, how do you prove that your work was used, and then what do you do about it? When are you going to sue Google? These sorts of things. So this is a unsettled, terrible area of the law for all of you, and I don't have an answer. So I apologize about that, but that's sort of the way it is. The second aspect of AI, though, that I am seeing more and more of, that publishers are requiring, that the public, quite frankly, is requiring, and especially the artistic community is requiring, is AI disclosures. So, and that AI disclosure would be, was AI used in the creation of this work, and to what extent it was used? And so that I am seeing that is starting to be incorporated. And so what you're doing, though, is you're basically, it's not so much the contracts are requiring it, but it's not so much a contract. It's more that they're requiring the artist to make a statement that states what level of involvement there was in that. And I think that is something, again, this is all brand new stuff. So this is something that is going to develop over time, and I guarantee you that it's going to be a much bigger and bigger and bigger issue. And it's going to become more and more prevalent, but it is starting to show up. And that would be, to go back to the talk, that would be under the warranties section, for example, where it's saying they're asking the artist to make a statement, the creative, do you own this? Did you do this? And then, is it original work? It fits in under that of, did you use AI, and how much and to what extent did you use it? So with that, you want to be, I guess the practical takeaway would be that you want to be very careful when making those statements if you do use AI, because as I understand, now look, I am not an artist by any means, as you can see, the boring stuff I do for a living. But if artists, as I understand it, are using it from anywhere from just spitballing some ideas that end up never in the final product, all the way to draw me a picture of an owl, right? And I just saw the owl. So the thing is that you want to make sure that you're being very specific in your disclosure as to how you did use the AI. So down the road, it's not going to come back to bite you, and then you're going to suddenly have some liability for the fact that you might not have stated exactly how you used that AI if you are incorporating it in any way in your work. So I think, what is it? Steam, I know this isn't comics, but Steam just has rolled out their AI disclosures, I believe, on the game. It's the online game marketplace. So again, you're going to want to make sure, if you're checking that box that no, I didn't use AI, you want to make sure that you're being honest. Does that address your question? You're asking me something that's basically developing as we speak, so I don't. Right. So
I'm going to chime in for a second, but Slice has a no AI policy, FYI.
Oh, I'm sorry.
No, it's something that we've also had to deal with over the last couple of years, and no.
Well, and I think the public in general is wanting and desirous of real human-made material. So I don't think it's not only going to be a requirement for disclosure. I think it's also, it's going to be an aspect of the work that's valued as we go forward.
We got time for one more question. If anyone wants to talk into the silly little microphone I got.
I probably don't need it, but
It's for the live stream.
it's for the live stream. Perfect.
Pardon me, sorry.
So first off, thank you very much. I thought that was very informative. Made me realize a lot of answers to questions I didn't know I had, and made me realize how little or how much I still have to learn. So my question would be, do you have any recommendations for, I don't know, just some beginner crash courses on understanding things like this more? If there's online resources, or if VLA has online resources.
So I'm sure VLAA has online resources. I think that is there any one good resource? It's really hard to say. There's a lot. This is the good thing and the bad thing. There is a lot of stuff out there, and there's a lot of helpful stuff out there, and there's a lot of unhelpful stuff out there. And the trick is determining which is the helpful and which is the unhelpful. So there is not a particular resource that I can necessarily point you to. What I think, and it sort of reiterate what I said at the beginning, is that now, no one shoot me here, but the AI for law, you guys can use AI to affect my industry. That's fine. AI is a great resource for this, in the sense of you can ask it for examples. You can put contracts that are given to you in and ask it to issue spot and describe stuff. And that is not going to get you a contract that I would tell you to run out and sign. But what that is going to get you is a contract that you're going to start being able to understand better and know the questions to ask, and then go from there. And the problem too with me making recommendations is I've got all kinds of resources, but you don't want to, the resources I use, you probably don't want to have anything to do with or engage with, because it's all, heavy law stuff. So I don't know. There's that. Now I'm going to say one thing, and can I say a bad word? Is this I don't know what your
PG-13, that's fine.
Okay, so this is a resource that I meant to recommend, and I don't know if any of you are familiar with Adam Savage from
Mythbusters?
Yes, Mythbusters. So he recommends this video, and this video is excellent, and it's called, you want to search on YouTube, and it's called, so the PG-13 version is FU Pay Me. And you want to look that up, and the obviously you know what the F part is there. So search for that. It's about 30 minutes. It's a guy who runs a creative agency and his attorney, and it is a great discussion about the importance of having these contracts and then making sure you have the ability to enforce them and that you're getting paid for what you're worth. So I would give you that. Now, that is not a resource for learning about these contracts, but listen, if you're willing to sit through an hour and a half of me, you can sit through that half an hour. It's a much better presentation.
What was it called again?
FU Pay Me.
F you pay me.
Yes. Sorry, I don't want to have to keep saying that, but okay. So
Well, thank you so much for doing our penultimate Comics U class of the year. We appreciate it. Let's give a round of applause one more time. And we're going to say goodbye to the live stream right now.